Hello everyone, this is Stuti Khare from Institute of Nirma University and interning under the Amikus Qriae. Today we will be talking about the doctrine of bad performance in India. The doctrine of bad performance finds its roots from the equitable rule of bad performance. In the year 1703, in the case of Foxcroft versus Leicester, the court held that it was not fair to the party who had entered into a contract and paid money to the other party on the basis of an estoppel contract and afterwards is considered as a trespasser to the property. It is against the morality to let the other party to enjoy the benefit of the money he had received by virtue of the contract made. The second case was Elizabeth Madison versus John Alderson in the year 1883. The court gave this doctrine of rule of bad performance in order to save the rights and interests of the transferee, which are violated due to the non-performance of the transferor and his default in fulfilling the obligation which he was supposed to. What was the need for the doctrine? Ambiguity as to whether the doctrine is to be strictly applied in every case just because it is prevailing in England was there in India. There was no proper implementation of the doctrine. In 1914, in the case of Muhammad Musa versus Aghor Kumar Ganguly, the doctrine was first made applicable in India. In the year 1929, the first amendment to the Transfer of Property Act 1882 was made, by which insertion of Section 53A, that is, the doctrine of bad performance, was done. With the enactment of the amendment, the doctrine of bad performance properly came into existence in India. Section 53A of the Transfer of Property Act defines bad performance. The ingredients of the doctrine were laid down in the case of Vasanti versus Venugopal in 2017, which are subject matter, valid contract, possession transferee, and subsequent bona fide transferee. The first is subject matter, where in it transfer of immovable property is important. The transfer must be of immovable property and it may be absolute transfer, that is sale of the property, or any right in the immovable property, that is lease, mortgage, license, etc. Second is it should be subject to consideration. A transfer thrusts duty on both parties, that is, the transferor and the transferee. Thus, it is duty of the transferee to pay the consideration for the property according to the terms and conditions of the contract so made. The second ingredient is valid contract. Here, for a valid contract under this section, the contract has to be in a written form. For bad performances, oral agreements do not suffice the purpose of a valid contract. In the case of V.R. Sudhakar Rao versus T.V. Kameshwari in 2007, it was held that the section will not be applicable for the possessions which are there with one party by virtue of oral agreements. The second thing is, only a written contract is not complete in itself. In order to be duly executed, the contract must be signed by the transferee himself or by any person who is authorized to sign on his behalf and whose signature will bind the transferee. Also, the language should not be ambiguous. The nature of transfer, that is to convey in whole or only some of the rights, should be ascertainable reasonably. In the case of Hamida versus Humair and others, it was held that the terms of the contract must be clear and upon reading can be reasonably ascertained that there is transfer of immovable property. Otherwise, in case of ambiguity, the section cannot be applied. The third ingredient is possession. The transferee should take the possession of the property in whole or in part by virtue of the contract. The possession may be taken after entering into the contract, or the other possession is before entering into the present contract. The transferee already had the possession of the property and now by virtue of the present contract he is claiming the continuation of possession of the property. In the third point, that is act in furtherance of contract, the transferee If he already is having the possession of the property, he has to do something in furtherance of the contract, like making alterations, revising clauses of the contracts, changing the rate of rent, etc. In the case of Kakuji versus Basantilal, mere retainment of possession is not an evidence to show an act in furtherance of part performance. The act must be in connection with the contract. In the case of Sardar Govindrao Mahadik versus Devi Sahai, it was held that any money given for purchase of stamp which is to be affixed on the deed is only an antecedent to the contract and will not be an act in furtherance of the contract because there is no reasonable nexus. The fourth point is transferee. The transferee should be willing to perform his part of the contract. The transferee who wishes to seek protection under the section must be willing to perform his duties or fulfill the conditions he is ought to perform. If the transferee himself defaults in performing his part or is not willing to complete the future conditions, then he is not eligible for the protection under the section. In the case of Jinnah Raj versus Sheikh Dawood Nachair, it was held that the intention to perform and the willingness must be absolute and unconditional in nature. If there are conditions attached to the performance of the part, then it converts into an offer and it cannot come under the ambit of this section. Also, the contract must be performed partly, meaning that the transferee must have done or adhered to the conditions agreed upon and the rest of the conditions must be performed at the later stage. The fifth ingredient is subsequent bona fide transferee. The rights of the bona fide transferee are protected in the proviso of the section, and the subsequent transfer is to be considered as valid if the subsequent transferee got the property for a consideration and had no notice, whether actual or constructive, regarding the contract or part performance. Also, even if all the conditions are fulfilled, the protection under the section cannot be given to the subsequent transferee and the section cannot be used against the subsequent transferee. The next topic is the basis of the doctrine. Here, the person who seeks equity must do equity, that is, willingness to perform the contract. So, a person who seeks equity must come with clean hands. Second is, equity does not look at the intention of the party more than the form and other things. The third is, equity regards as done what should have been done. It means that if by force of law or some contract, if a party is supposed to do some act, the law supposes it to be done even before it actually happens. Thus, part performance was misused by the transferor and the section was amended in the year 2001. Now it is to be read with section 17 and 49 of the Act, which makes it mandatory to register the deed, which was not the case before. The nature of rights under section 53A. Statutory right. Under English law, the right under the doctrine is an equitable right, but for Indian law it is only a statutory right of the transferee. In the case of Achari versus Venkata Subha Rao, the court held that right under section 53A is a statutory right for both the plaintiff and the defendant. The second is title. Under the English law, by virtue of the doctrine, a title is created in the property, but under the Indian law, it does not confer or create any title of the transferee in the property. In the case of Ramchandar versus Maharaj Kunwar, the court was of the opinion that the attempt of the transferee to claim title under section of 53A is completely unjustified and that there is no title of the transferee on the property to claim even though he has possession of the same. The third is passive equity, no right of action. Under English law, it can be used to enforce right as well as defend it. But Indian law only permits the transferee to defend the possession of the property and not take an action of claiming title over the property or recovery of possession of the property. Thus, it is a shield only and not a sword. The landmark judgment will lay down about the nature of right under Section 53A is passive in nature and the transferee cannot sue is the case of Prabodh Kumar Das versus Tanmara Tea Company. From the evolution of the doctrine to its enactment and amendment in Indian law, what I can conclude is that the doctrine of part performance was the need of the society. Like the English law confers title on the transferee and oral agreements are valid, if the same would have been applicable in India, it would have been misused to the core. Though the doctrine is for the benefit of the transferee, but the imposing of statutory ban on the transferee for conferment of title keeps the balance between the rights of both the transferor and the transferee. It has been correctly named as the weapon of defense, but not the weapon of attack. Thank you.